With regard to the sentence, with the purposes and principles, the sentence must comply with those purposes and principles set forth in 292911A. The overriding purpose to punish the offender and protect the public from future crime by the offender and others. Using the minimum sanction I determine accomplishes this purpose without imposing an unnecessary burden on state or local government resources. The court is to consider the need for incapacitation, deterrence, rehabilitation, and restitution. The sentence should be commensurate with and not demeaning to the seriousness of the offender's conduct and its impact on the victim, and consistent with sentences for similar crimes by similar offenders. In looking at the factors outlined in 292912B, the only, with regard to whether the conduct here was more serious, the only factor that applies here is that the victim suffered serious physical harm. In fact, the victim did suffer his death. None of those more serious factors apply. Whether the less serious factors apply under 292912C, the victim induced or facilitated the offense, no. The offender acted under strong provocation, no. The offender did not cause or expect to cause physical harm to a person or property. I find that factor, he did. Had he been thinking about it, being intoxicated, driving 127 miles an hour down the highway, I believe you can expect to cause physical harm to persons or property. I do not find that substantial grounds exist to mitigate the offender's conduct. So one of the less serious factors I found. Whether recidivism is more likely under 292912D. Whether the offense was committed while the defendant was on bail, awaiting sentencing on community control or PRC. In this case, in fact, the defendant was on community control for a physical control. That physical control sentence was imposed on April 6, 2023. The defendant was given 180 days in jail and 177 of them were suspended, and he was given probation with the condition that he complete a chemical dependency assessment. So in fact, that making recidivism more likely factor does apply. The defendant has a history of criminal convictions or juvenile delinquency adjudications. In fact, that is true as well. Mr. Lowry has a conviction for assault on January 7th, 1997. Disorderly conduct in 2015. Attempted abduction in 2017 and domestic violence. Criminal damaging in 2017. Those were all part of the same case. Domestic violence in 2016. Then the physical control that I've already mentioned. Attempted drug abuse in 2023, April 6th as well. And then this case. And then after this case, the defendant picked up a subsequent DUI. So yes to whether he was on community control. Yes to history of criminal convictions. Yes to not responding favorably to sanctions imposed because this is a violation of his probation in the physical control case. Yes to showing a pattern of alcohol use related to this offense, and he eventually got treatment, but it wasn't until after the DUI that came after this case. Unlike many cases, I do find the one factor that the defendant does show genuine remorse. Quite frankly, it is something I never see in this courtroom. Somebody who comes in and absolutely takes responsibility for what they did and in fact admits to the things that we all know happened but didn't have enough proof. That never, if ever, happens in here. Whether recidivism is less likely, I do not find that he has, well, he doesn't have any prior juvenile cases. He does have prior adult convictions. He has not led a law-abiding life for a significant number of years. I do not believe the offense was these circumstances could occur again. I do find, however, that he shows genuine remorse. That is striking to the court. Whether or not people believe that or not, that's up to them. I've sat and presided over hundreds, if not thousands, of sentencings where individuals absolutely refuse to take responsibility and admit to their conduct. I don't find that that's the case here. The presumption in this case is prison. I do not find that there are any factors that can the factors as combined cannot overcome the presumption. In looking at the sentencing guidelines, I also do not find that a minimum sentence would, in effect, punish the offender and protect the public from future crime, based on specifically based on the recidivism factors that I've outlined. The defendant's record and continuing to pick up DUIs even after this incident happened. Those particular, his record and that subsequent DUI, and it's too much for the court to overcome. The damage in this case is so great that a sentence must reflect the magnitude of the harm that was inflicted. The counsel run concurrent. Count 5, 11 months. Count 1, your minimum sentence is 7 years. Your maximum sentence is 10.5 years. All right, you're ordered remanded and transported.
Thank you, Your Honor.